one of the things that I want to highlight though, what isn't a trust, right? Is power of attorneys, right? So sometimes people there's already enough confusion. Like, well, I have a trust. I don't need a will. You do still need some kind of will to just say, hey, anything that wasn't in my trust, I want it to go to my trust. It's called a pour over will. But so that's kind of those two documents. But power of attorneys are totally different. And
you can have a couple different kinds of power of attorneys as well.
Yep.
So there's the financial power of attorney, and then the advanced healthcare directive, or the healthcare power of attorney, essentially.
Sure. Yeah, you can do it a little bit different way. And it's going to vary state by state, potentially on terminology.
Yeah, that's true.
Information presented on this program is believed to be factual and up to date, but we do not guarantee its accuracy, and it should not be regarded as complete analysis of the subjects discussed. Discussions and answers to questions do not involve the rendering of personalized investment advice, but are limited to the dissemination of general information. A professional advisor should be consulted before implementing any of the options presented. Encompass More Asset Management LLC is a registered investment advisor with the U.S. Securities and Exchange Commission and only transacts business in states where it is properly registered or is excluded or exempted from registration requirements.
Hey everyone, welcome back to a very specific episode and targeted episode of the Ducharme Wealth Management Podcast. Today we are going to be talking about estate planning. No attorneys in the studio with us today. It is Carissa and myself. We're the two lead advisors down in St. George. And we have a focus we're going to have in quarter one here. With all of our clients that are currently engaging us, and just working on helping them make sure that their estate plan is what I call buttoned up, right? My dad would like to use the term, like keeping the financial house in order. Whatever way you want to look at it, what we want to do is make sure that clients have a estate plan that is done and documented properly and executed properly. And what I mean by that is you can write, for example, you could have a trust, but if you have a investment account that the beneficiary is still labeled as, your brother, but your trust says it should go to the kids. If what's labeled in the account it says it goes to the brother, that still is what governs. So what's in writing is what governs in estate planning. And so it's really important that we take just a bearing check of that and say, do you have what you need? And is everything kind of documented correctly? And I think that we have clients across the spectrum, some that have very buttoned up, dialed in, complex, advanced estate plans, and some that have, some of the things done, and it's worth just revisiting and making sure nothing's changed. And then we have clients that have yet to do an estate plan. And we've added some capabilities at the firm recently to be able to help facilitate that in a really cost-effective manner for people. And so what we want to do is just talk about a couple of the things today, like what makes an estate plan, and then what do you want to look at to make sure that it's buttoned up and, just organized and done correctly and executed. Carissa, you want to add anything there?
No, I'm, I think this is something that's really important. When I was in banking before becoming a financial advisor or wealth manager, this was something that I had to deal with a lot with clients that would come in, is their loved ones would pass away. They had thought that everything was all taken care of, that it was in the trust, and they came in to try and do, final expenses for their loved one, trying to get everything all taken care of. And they couldn't access the account because it wasn't actually listed in the trust, or they weren't listed as the beneficiary, or, whatever the situation was. But there were just so many times where I saw that it wasn't done properly. And so that I just got to see, what happens when an estate plan is not done correctly and when it is not, listed correctly on your accounts. And so I'm really excited to be having this as a focus for our clients this quarter, making sure that they all have that, so that when something happens to them, their family is all taken care of and their wishes can be carried out the way that they want them to be.
Yeah, I think that's so everyone has an estate plan. Mm-hmm. It's your plan, or it's the state's plan,
Yep.
right? So you have a plan by default, and it's the laws, the governing laws of the state in which you reside. And typically, it's a more costly process that's very cumbersome and not always what you're looking for.
Yeah.
It could be very contrary to what you're hoping to happen.
Yep. When you hear the word probate, that is going through the court's process to be able to follow through with the court's estate plan.
Right.
Essentially.
And it's a public process.
Mm-hmm.
I think that's the biggest thing to think about is that probate is a public process. And so any of the assets that go through probate are full public record. Mm-hmm. So my dad actually, when he was a CFO of a plastics manufacturing company back in the 90s, when they had competitors that one of the partners would pass away and didn't have an estate plan done, they would have to probate the ownership of the company, even, through buy-sells agreements. A lot of times, like it still wasn't all done properly.
Yeah.
And so to them, they thought like, well, we'll just go through probate. Everything else is going to work out okay. But it's public record. So now my dad was able to go in and get all the records of the company and understand like where they were getting, supplies or bidding stuff. There was a lot of competitive advantage that he was able to gain in the business as a CFO against his competitors because they hadn't done their estate plans correctly. And so you want to keep your private matters private.
Yeah.
Probate is not private. And in particular, if you have people out there that might be able to make a claim, or there's just people that they wouldn't be able to make a claim really, but they're just, cuckoo in the head and they think they can make a claim.
They're going to try it.
They're going to try it. They can hold up the whole process and just make it a painful experience for maybe the people that are the rightful beneficiaries.
And a lot more expensive.
And it gets, just so much more expensive.
Yeah.
And so, you want to avoid probate when you can, typically. Again, I'm not an attorney. You're not an attorney.
Right.
I just think that's generally acceptable, sort of a generally acceptable idea.
Yeah.
So how does somebody avoid probate?
So to avoid probate, you need to have your own estate plan in place, typically a trust, because even a will can still go through probate, and most oftentimes will.
Well, a will has to go through probate.
Yeah.
In fact, probate means to prove, right? So probate is actually to prove the will.
Yep. So
and
that
have
comes
the
down
court
to the
agree
judge, essentially. Of whether or not they agree with what is listed in that will and if they're going to carry out those wishes or if they need to make adjustments or changes to it at that point.
Yeah. Yeah. And there is a lot of very specific and it varies state by state, very specific parameters around what constitutes a will or not is the first thing. So like in some states, if you type up a will, like on your computer, print it off and, sign it while it's notarized, that might not be, in a lot of states, that might not be considered a will.
Yeah.
It might not be considered valid and properly executed. And so you have to be really careful and understand like exactly what you're doing with this, and make sure that you get some right guidance. And so like, hey, writing on a napkin, I want Joey to get the Corvette and I, want Barb to get all the savings account. That in some states might work if it's in your handwriting.
But most of the time it's probably not going to hold up.
But the biggest thing is that all of a sudden, when it goes to court, it could be what they call contested. So the third kid that you forgot to put in there could say, hold on, the other two kids had, undue influence over mom or dad. And, now it's a big legal battle again, right? So trusts are interesting because they don't go through probate.
And they're private.
And that's what keeps them private. So trusts are viewed sort of like their own individual entity or person, kind of like a business, right? Like even if you're a small business owner, you're gonna be very familiar with this concept. Like there's a difference, even though you are the business, there is a difference between you and the business, right? You sign things on behalf of the business, right? But you're not the business itself, right? You could sell the business. So the trust, if you're looking, and most people are going to be looking to execute a living revocable trust, which means you can take the assets out of it anytime. You still maintain all control, right? And but it is sort of its own entity. And so the trust owns things, owns property, right? So you would potentially have your home maybe retitled in the name of the trust. Your brokerage accounts can be retitled in the name of the trust. Your
bank accounts.
Your bank accounts, right? There's different things that could be retitled in the name of the trust. And when you pass or become incapacitated potentially, depending on how you design this, another person just becomes the trustee, which is the person that acts on behalf of the trust, but the trust is still its entity that still owns everything. And so the trustee can change and the beneficiaries remain the same. There's ways to do it, I suppose, that you could change beneficiaries, or they may change over time depending on their status of being alive or not, or whatever it might be. But the point being is that is kind of a living entity, if you will. And so it doesn't have to go through the probate process. That's where it starts it keeps everything private. And it also can govern out a lot of different things for you. Trust, right? Is power of attorneys, right? So sometimes people like there's already enough confusion. Like, well, I have a trust. I don't need a will. You do still need some kind of will to just say, hey, anything that wasn't in my trust, I want it to go to my trust. It's called a pour over will. But so that's kind of those two documents. But power of attorneys are totally different. And
you can have a couple different kinds of power of attorneys as well.
Yep.
So there's the financial power of attorney, and then the advanced healthcare directive, or the healthcare power of attorney, essentially.
Sure. Yeah, you can do it a little bit different way, and it's going to vary state by state, potentially on terminology.
Yeah, that's true.
But I think like the biggest call out is that, hey, a trust and a will are largely for after you die. Right? That is, it's for after you meet the end of your financial plan.
Yeah.
Right? And so when people say, hey, you don't do it for yourself, you do this for your beneficiaries, you do this for your kids, whatever, that much is true on those two pieces, right? And that's where sometimes people say, well, when I'm dead, it's not going to be my problem anymore, so I don't have to worry about this one.
I also hear that, I don't have enough money to get one anyways, and so it doesn't matter.
If you're one of our clients, don't let that be your excuse, please. We have some great resources to help you facilitate. However, getting back to it, the power of attorneys are very much the opposite. The power of attorneys are for pretty much your benefit while you're still alive.
Yeah.
But in the worst kind of way. And what I mean by that is you are incapable of making your own decisions or taking care of your own affairs. And somebody has to help you while you're still alive. And it's very common. And that is a scenario that can, once again, be very costly, because if you don't have these documents in place and you become incapacitated, then your loved ones have to go to court. And rather than, it's not probate, but they have to go to court and get a conservatorship appointed, where then the court appoints them as your kind of guardian, if you will. Yeah. Again, that process is going to look different, I believe, like state to state, but it can be a lengthy and costly process, right? Yeah. And so if you come into a situation where you, fall and break your hip and you go into surgery, and now you're like, you come out of it. This is what happened. Like, I will give you the exact situation of my grandfather. How about that? He literally did. He was doing pretty good in life. He's in his mid 80s. Fell coming home one day. The storm door closed, created negative pressure, and bounced the front door back open into him. It kind of just knocked him over. Tripped a little bit on a rug in the front hall, and he fell, broke his hip. He came out of surgery after having gone through anesthesia for that, and pretty much had dementia. And it was downhill for years and years after that. However, had we not had the estate plan done and properly executed, remember, he's an adult. There's no carve out, at least that I'm aware of, in different states that says, well, as long as you're his spouse, we'll let you make the decisions. We'll take it, your word for it. You have to have that power of attorney. And so because the power of attorney was there, my grandma and the key family members that were helping in that situation could help make those decisions and get my grandpa the care that he needed instead of having to wait and go through conservatorship and deal with all this stuff. It was very easy and executable. And those were documents that they needed for the next 5 years, before my grandpa finally passed. And once it happens, right? Like once my grandpa had dementia, it was too late.
You can't go and
you
get
can't go get a power of attorney, because in order to sign those documents and say, yes, I'm willing to give my spouse or my kid or whatever this power of attorney in the event that I am, incapacitated or incapable of caring for myself, you are incapable of signing that document. And so the planning side is very key on that. And people should want that to be there. It's very simple. It's a pretty simple document. It's like not a big thing. But when you need those documents, you really need them. And it's too late to get them once you need them. Yeah. So, that's power of attorneys.
Yep.
There's a set of documents that kind of focuses on healthcare decisions, and there's a set of documents that focuses on more like financial decisions. So that way people can help guide the doctor in your care. And then also they can access your financial statements. So that way they can,
maybe
pay the bills, pay the mortgage, pay the taxes, whatever needs to happen, right? Work with your financial advisor to, continue to have your portfolio managed in accordance with how you need it, because at that point it might actually be different than what you had been doing. Again, like in our situation, if we have a client that, ran into this issue and all of a sudden we need to manage assets differently, but their kid is calling us saying, we want you to manage mom and dad's assets more conservatively all of a sudden, we can't necessarily act on that. Right. We have to, and we can't really tell them what's going on with mom and dad's portfolio or finances or what we know until they kind of have that, now if they present the power of attorney, it's a different story. Right. And that's exactly what I'm talking about.
Yeah. Because without that document, we have no right to talk to them about that, because that's private information at that point.
Yeah. Okay. So I think the other, that covers the, kind of the stuff for after you're gone, the stuff for while you're here. And we're not touching on everything today. We're talking the quick basics, things you should be considering. The last thing I want to talk about is beneficiaries on accounts and how beneficiaries are labeled and assigned, and why that might be important.
Super important.
You spend enough time in the banking and institutional banking side. Do you have any good stories to share about where, somebody's estate plan maybe said one thing, but their beneficiaries were labeled something very different, and the effects that the outcomes of that?
Yeah. There was a woman that I was working with. She came in to the bank, and she was the sister of a client of the bank, and she was listed as the executor on the sister's estate. So she was going through the trust and trying to just button everything up for the whole family, right, on behalf of her sister who had passed. So the sister who had passed away had been married, and on her bank accounts, it was a joint bank account with the sister and her spouse. Now, the spouse passed away first.
Okay.
The sister, the client, never did make any changes to that account. So it was still listed as a joint account with her and her deceased spouse. And so instead of putting it into the name of the trust or even having somebody else listed, essentially it was that deceased husband that would have been listed as the beneficiary, right? But now the sister's coming in and she's like, oh, everything's in the trust. And unfortunately, I couldn't even talk to her about these accounts until she went and got her trust. We had to review that through the bank. And then she actually had to go, and those accounts had to go through the probate process. Even though there was a trust in place, it just wasn't listed on the bank accounts.
Yeah.
So it became a really long and tedious process. I worked with this client for months trying to get everything in order.
Yeah.
Where if the sister had just simply gone back into the bank and added the trust as either the owner or the beneficiary on her accounts,
Yeah.
it would have made a huge difference, saved a ton of money, saved a ton of time, and a lot of headaches for her sister, who is the executor.
Yeah, you got to remember what is on paper is what's going to govern. And so that's where it sounds like in this case, now I don't know the facts exactly, but what it sounds like is the trust and the estate plan that they had a pour over will that said, hey, if there's anything that we missed or forgot about or didn't name specifically, like we want it to be probated and given to the trust, right? Because then from there, the trust can allocate, give it out and distribute it however it needs to be.
Yep.
But that still has to be probated. And it sounds like it scooped it up in this case because there was essentially no beneficiary listed.
Yeah.
What gets to be a really big disaster is if you have a situation where there was like maybe a divorce and somebody forgets to go update on their 401k, their ex-spouse from being the beneficiary. And so now they pass away. The ex-spouse is the beneficiary, regardless of what the estate planning documents say, the new spouse being alive and well. And you know what I mean? All these things, like that's a disaster scenario.
Absolutely.
Now I think we can think about other scenarios, right? That could even happen. And it's kind of an endless list, but the important thing to understand is like, it doesn't matter what you think is going to happen or what you hope is going to happen or what you believe is in place or think you remember what's in place. What matters is what the ink on the paper says.
Yep. So
to that effect, I just want to remind like all of our, any of our clients that are listening to this, in Q1, we're going to be sending out a report that just highlights what we have on file for you, what documents that we understand you've created, any of the accounts that we manage, what we have listed as the beneficiaries, and all of the accounts you have that we're aware of, we'll list out any of the beneficiaries that you've told us. You know what I mean? So we're going to give you what information we sort of have in a custom report to you, and we're going to ask you to review that and tell us what updates need to happen, right? Yeah. But if that's a great time to, at that point, when you're reviewing that, say, let me go log into all my stuff.
Yes.
And
highly encourage you to
double check and see if there's any updates that you need to make on stuff that we don't manage. If you don't know how to do that stuff, or if you're like, well, I don't have something, or what I have I know is incorrect and I need to change it. We are so happy to help guide you through the process of, the considerations of who you should put as a beneficiary. Should you do your spouse? Should you do your trust? Should you do this or that? Or, we'll help guide you through that thought process as it relates back to the rest of your financial plan.
Yeah.
You got to just ask the questions. So these reports are just a great way to start the dialogue. And then from there, start answering questions that you have and go through whatever processes we need to help you get what you need, get it done, get it buttoned up, and make sure that you are on track with a solid estate plan. If you are listening to this and you're one of our clients and you don't get a report for some crazy reason, please reach out to us. Yeah. Just let us know, hey, I didn't see my report coming through. I'm really eager to review that. We'd love to get it to you right away. And do whatever we need to do to support you. Anything else you want to add?
Do you want to talk about the new capabilities that we have to help with that?
I would just say if you don't have an estate plan yet, we either have a really great network of estate planning attorneys and professionals that we've worked with, and we can either help facilitate with those attorneys or other technologically driven solutions that we have that might be a good fit for you as well.
Yeah. So
don't let cost be the thing that holds you back from having everything kind of done right and asking questions.
Yeah.
Definitely just engage us And, we're here to help you. We're here to serve you. That's why we're here. That's what gives us joy, right? We do this because we really do care so much about our clients. So, that being said,
reach out. We're excited to help you make sure your estate plan's in order.
Okay. Talk to all you guys soon.